A conflict of interest arises when a lawyer cannot represent one client's interest without doing damage to another client's interest. Our duty to not represent clients with conflicting interests is canonized in the bar rules. It is against the law for me to not identify a conflict. However, our clients can waive a conflict. This is a waiver I use from time to time. And not every co-defendant case necessarily presents a conflict. The United States Supreme Court has recognized that sometimes it is permissible for one attorney to represent two co-defendants. Sometimes figuring out the intricate relationships between defendants and where our duties lie is quite a challenge. This example would make for an excellent law school exam on ethics and professionalism. This was an actual fact pattern and the chart my paralegal devised to sort it out. In this example, Wesley Mitchell, our client, for whom we have two open felony cases, one in each of two separate counties, and who was a witness in our client Jane Bridges' case, is charged with aggravated battery for breaking Robert Jones's face. Denise Martin, Michael Martin, and Lucy Gretchen Coker are also charged with Wesley Mitchell as parties to the crime of breaking Robert Jones's face. We've represented Robert Jones 2 times before. We had 2 open cases on Lucy Gretchen Coker, and she is the mother of one of our former juvenile clients, Jared Coker. I've changed all these names for confidentiality concerns. Lucy is the sister of Randall Coker, who has 5 open conflict cases. The fight occurred over at David Hansen's house, who we have represented 4 times in the past, and he's a potential witness. Then, on a later date, law enforcement goes to Mitchell's house to serve the warrants for the aggravated battery. Bridget Baggins is there, and she is in possession of some methamphetamine. Bridget Baggins is the estranged wife of our client Henry Baggins, 1 case open, 1 closed, and she is the mother of our former juvenile client, Jeremy Wilson. Plus, there was another woman at the fight whose name we didn't know at the time who might be a potential witness, and it is not at all unlikely that we have had her on something else or have her on something now. It can get to be a big mess. Sometimes we're not able to make enough of a determination to declare a conflict up front. In that case, we open the file and staple a note on it to alert the lawyer who gets the case that there may be a conflict or two lurking somewhere inside. We must frequently engage in this kind of analysis and find it helpful to diagram the puzzles. These charts illustrate a problem that is unique to a dedicated public defender's office. In rural areas especially, there are various isolated communities of poverty which are breeding grounds for criminal activity. As these slides demonstrate, it can become rather complicated as yesterday's witness becomes today's victim and tomorrow's client. The framers of the Indigent Defense Act of 2003 failed to take into account this circumstance in allotting adequate funds for representation in conflict cases. Next, we'll see how that failure manifested itself here in the Northern Circuit in the Cantwell lawsuit. The Sixth Amendment and the Equal Protection Clause of the Constitution say that poor people are entitled to the same conflict-free representation as those who can afford a lawyer. The Indigent Defense Act of 2003 was an elegant, practical, and promising beginning in addressing the questions of how to go about providing cost-efficient and effective indigent defense in Georgia. Nevertheless, it has 2 major shortcomings. The first is its weakness in assuring that the burden of effective representation is borne uniformly across the state, and the second is that it failed to accord conflicts their unique and significant role as they concern the operation of a dedicated public defender's office. It didn't take long before the consequences of failing to realize that conflicts play a significant role in indigent defense became evident. It was quickly evident that the true cost of conflicts had not been planned for in the GPDSC budget, and that spending on conflict cases was escalating at an alarming rate. In the first 3 months of fiscal year 2006, which was July, August, and September of 2005, 6 months into their existence, they'd spent nearly $400,000 on conflicts. Then, a year later, during July, August, and September of 2006, they spent more than 2.5 times that much. The problem of how to pay for conflicts was made worse. The legislature cut the appropriations for GPDSC. During the succeeding years, as the problem with funding conflicts grew more acute, the legislature continued to cut our funding. In response to the legislative cuts to our budget, Mack Crawford asked the public defenders to find a cheaper way to handle conflicts. And early in 2007, the majority of the CPDs agreed to handle conflicts in-house. I feel a strong commitment to my clients and the notion that the Sixth Amendment says they are entitled to the same conflict-free counsel that paying clients get. To my mind, the bar rules also spell it out clearly. We cannot handle conflicts in-house. I engaged in a sometimes rancorous debate with my fellow CPDs over my decision to not handle conflicts in-house. The GPDSC sought the advice of the state bar as to whether it was permissible for public defenders to handle conflicts in-house. On April 23, 2010, the bar issued an opinion that sits foursquare with the position I had been advocating. This chart reflects the conflict rates for the various CPD offices around the state for 2007. You will note here in the column on the far right that a number of the judicial circuits had conflict rates in the mid-teens. Here I've cut out a slice showing my circuit and the 5 circuits on either side of me. These numbers reflect the period before most other offices started handling their conflicts in-house. I do have a high rate of conflicts, and I attribute that to problems unique in my circuit, the same problems which contribute to the DA's abysmally low conviction rate, which I described earlier. After the various CPD offices began handling conflicts in-house, their conflict rates dropped significantly. These extremely low numbers reflect that a public defender's office is handling conflicts in-house. Of course, the only problem is handling conflicts in-house was of little avail. GPDSC continued to have a significant budget shortfall. My budget for conflicts for fiscal year 2008 was $120,000. I thought I had it covered with my contracts. In June 2008, the CPDs met with the GPDSC at Amicalola Falls State Park. Larry Snyder, then GPDSC Conflicts Director, led the discussion about our conflicts budget. We were each given our budget figures. I was handed this, the first time I'd seen these numbers, and when I saw that I'd gone nearly $50,000 over budget, I was floored. And I was likewise shocked when Larry informed me at that same meeting that my budget for fiscal year 2009 was going to be only $37,000. A $37,000 budget wouldn't cover the $50,000 deficit. I had no money for conflicts. I asked Larry how I was supposed to pay for conflicts. His response was to the effect that this is just how it's going to be. I returned to my office and told my judges about the problem and the looming situation. I also informed my contract lawyers that I would not be able to renew their contracts. On July 3rd, 2008, I wrote Larry Snyder, beginning of a series of exchanges of emails. Larry's response was non-responsive. I wrote him back that same day, and the exchange continued. Judge Bailey said he wasn't going to make the lawyers work for no pay. Judge Bailey allowed the contract lawyers to withdraw from their cases after July 1st, and we stopped appointing lawyers to the conflict cases. I explained to Larry how handling conflicts in-house was not an option for me. I'd already explained that I have a small office with lawyers of varying degrees of experience. It is vital that we be able to discuss our cases. Moreover, various lawyers in my office develop expertise in various matters. It's important that we share that information amongst ourselves. I also observed that the whole problem of conflicts was built into the system from the outset. Larry gave me another non-responsive reply. But I needed an answer. There are bad consequences when people don't have lawyers. For example, sitting in jail on a minor charge with no one to turn to can be an utterly demoralizing experience. There are likewise disheartening effects on their families. Then on July 10th, Larry sent me this email. Mack says you're not getting any more money for conflicts. Larry suggested that I handle conflicts in-house. Let me depart from the timeline for a moment. Larry was the conflicts director at GPDSC. Many CPD offices were now handling conflicts in-house. It became evident to the folks over in the Lookout Mountain Judicial Circuit that if they're going to handle conflicts in-house, they will need to be able to identify who is who. So Carmen Williams asked Larry if there were a way to modify the search function of the database to make it easier to identify those relationships. Larry responded in his typical fashion. Carmen pleaded it would be helpful to know this stuff. Then this. You don't have to search for conflicts. If you don't know there's a conflict, you can't have a conflict. The fact is, to be effective advocates for our clients, we do have to know the relationships of all the parties. Not to mention that Larry's position as director of the GPDSC Conflicts Division was contrary to the law. Back to the timeline. One lovely autumn day, I'm working at home on my front porch. I get a call on my cell phone. It's Mack. He's gotten word that the judges in the Northern Judicial Circuit are dismissing those conflict cases. Mack's question revealed a disturbing naivete. That is, a judge is simply not going to dismiss, say, a murder charge because there's no lawyer to represent the defendant. I explained to Mack that the judges are not dismissing those cases, rather the judges had allowed the lawyers to withdraw. And given my proclivity to loquaciousness, I have no doubt I gave him an earful about our problems. Mack can deny any recollection of that conversation to his dying day, but I told him. Actually, I was thrilled that he'd call me. I hadn't gotten any help from Larry. I was hoping that Mack could help me with my problem, but that didn't happen. In fact, it was quite the opposite. We'd been getting calls from relatives desperate for somebody to help get their loved ones out of jail. There were conflicts. They didn't have lawyers. They were calling the jails, the clerks, and the judges. Judge Bailey, our chief judge, tells me to represent these guys in a bond hearing. Our position was that to do so would be an impermissible conflict of interest. We sought advice from the bar, and the bar affirmed our position. These people went unrepresented, and one of them wound up a named plaintiff. We got dozens of calls from concerned family members, and I told them to call Larry. I gave a lot of people Larry's phone number. January 23, 2009, GPDSC met in Athens. I was not present. Having a caseload as well as being responsible for running my office, I don't have the luxury to attend many council meetings, even this one only 35 miles from my office. I later learned that the Southern Center for Human Rights was there, and so was one of my former contract lawyers, Warren Cantwell, and apparently so was Bill Rankin. The next day, an article appeared on the front page of the Atlanta paper. I want to emphasize to you that this article appeared in the Atlanta Constitution on January 24, 2009. It was on the front page. It would be entirely reasonable to assume that Mack Crawford had either read it or had heard about it. After all, it was about the state agency of which he was the head. Shortly after that meeting in Atlanta, I got a call from Judge Bailey. He asked me to give him the list of names of all those conflict defendants sitting in jail without a lawyer. This is the email I sent to my paralegals asking them to get that information. Then the Southern Center started showing up at our arraignments and counter calls. The Southern Center filed the Cantwell lawsuit in April 2009, alleging that these defendants sitting in jail without a lawyer were being denied their Sixth Amendment right to counsel. They served Mack with a copy of the lawsuit in April that same month. Let's review the timeline. In July 2008, Mack says I'm not getting any more money for conflicts. Then that fall, I explained to Mack what's going on. Then, January, there's a front page article in Atlanta paper about it. Then, in April 2009, Mack is served with the Cantwell action. As you are probably aware, ever since the legislative cuts, there had been an ongoing battle concerning payment for representation in conflict cases. You may have even been one of those dozens of lawyers who've sued Atlanta for cutting your bills, paying only pennies on the dollar for the conflict work you did for them. Now, they're telling the judge it's actually not a money problem at all. Rather, GPDSC's defense in the Cantwell action was to blame me for not informing them that I was having significant problems in the Northern Circuit. I was utterly dumbfounded when I heard about this. For Mack to have been telling the truth at that March hearing, then Larry Snyder didn't think the problem I described in those July 2008 emails was important enough to convey to Mack, or Mack must have thought, since we weren't going to get any more money for conflicts, there was nothing he could do about it. Once I explained to Mack in that fall 2008 phone conversation the judges weren't dismissing the cases and were instead merely allowing the lawyers to withdraw, then there was no problem in the Northern Circuit. None of those dozens of concerned family members who called me wanting to know about a lawyer for their loved ones actually called Larry with their concerns. But the real kicker is Mack didn't read or hear about the front page article in the January 24th, 2009 edition of the Atlanta Constitution about the problems in the Northern Circuit, problems concerning his agency. Nor did his wife or his secretary or her husband tell him about it. Nor did Sarah Haskin, the number 2 person at the agency, nor her husband, nor Larry Snyder, nor his wife tell Mack about it. Nor did anybody else in the GPDSC office on the 2nd floor of the bar building. Nor did anybody on the council ask him about that front page article. Nor did any of his hundreds of dear friends all over the state who knew he was the director of GPDSC and ask him about the problems in the Northern Circuit. I was not originally named as a defendant in the Cantwell action. Consequently, I was not allowed to put up a case. I was also subject to the rule of sequestration and was not allowed to hear what any of the witnesses had to say, including Mack Crawford and Jim Stokes, the current conflicts director at the Georgia Public Defender Standards Council. However, on the eve of settlement, I agreed to be added as a defendant to help effect the settlement to assure that GPDSC would continue to pay for representation in conflict cases in my circuit. I take seriously my oath as a lawyer and a public defender to protect my client's rights under the Constitution. Not only the Constitution of the United States, but the Constitution of the state of Georgia as well. This chart shows the dramatic increase in the prison and probation populations of the United States. Georgia at last count is number 4 in the nation. Never has there been a more compelling need for effective representation of indigent criminal defendants. There are those who argue that we cannot have the 6th Amendment apply to poor people because it costs too much. If one considers the Constitution as the foundation on which is built this nation's success, chipping away at that foundation because we can't afford to maintain it will lead to the failure of that foundation. In that regard, we cannot afford to not have the 6th Amendment apply to poor people. This country was founded on principles informed by knowledge and wisdom. This is an illustration of many well-informed, great thinkers as they struggle with perhaps some of the most profound issues in the history of mankind. It was no easy task, but what they achieved has become the envy of the world. I urge you to use knowledge and wisdom in making informed decisions with regard to the future of indigent defense in this great state. As I trust I've shown here, the problem of conflicts has a unique character in the context of a dedicated public defender's office. The question becomes how to address that problem without sacrificing the rights guaranteed to all of our citizens under the constitutions of both Georgia and the United States. It is no easy task. Thank you for your time.